Hello, YouTube. I am Vince White. I am an employment attorney, and on this channel, we answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. We have a question here from YouTube user Larissa Dirkswager, who asks us, let me get this configured here. Okay, there we go. There we go. Good strategic advice. So she's obviously commenting on another video. She or he, I have no idea. Still, do you think the question of previous litigation is legitimate, helpful, and relevant? So the question that Larissa is commenting on was on discovery demands and whether to comply with certain discovery demands or fight them and things of that nature. And one of the discovery demands was, I think, about prior litigation. The defendants wanted to know if the plaintiff had any prior litigation in the past 5 years. And so Larissa asks, still, do you think the question of previous litigation is legit, helpful, and relevant? Well, I can certainly see why the defense would want to have it. No question. I can like, that makes perfect sense to me, and I can get into why. I can also say that I can certainly see why the plaintiff would not want to turn over that information in certain circumstances. But Larissa continues. I have reason to believe that my opposite plaintiff is an extortionist and uses litigation to rob vulnerable people. He frantically resists turning over information and denies that he sued his landlords before, refusing to produce his previous landlords' names and addresses, etc. So I don't know anything about landlord-tenant litigation, but listen, it's a field of law, employment law, where there is some danger of repeat litigants, right? There's a famous like viral video on the internet about a gentleman who sued every employer he's ever worked for in his entire life. And often he gets settlements because, it's often in this field cheaper to settle with someone than it is to fight it out with them. Now, that's a rare occurrence, but in discovery, you can go for everything you want to some extent. And listen, there's going to be some tussle about whether you get it all, but you can go for everything you want. And so it makes sense that you would have discovery document requests and interrogatories aimed at addressing situations like that. And I can even give you some stories, right? Like, so there's times when, as a plaintiff's side attorney, someone will come in and they'll have their fourth case in 5 years, and you'll say, can you explain to me what's going on here? Why, we'll use a hypothetical, right? Why do you have 4 sexual harassment cases against 4 different CEOs inside of 5 years? And the answer could be, listen, my job title requires me to travel with these CEOs, and people get drunk, and we're all over the world, and we're in great locations, and these CEOs, forget themselves and act the fool and do regrettable things, and then I have to defend myself and I have to litigate because I've been sexually harassed. To which I would say, fair enough, completely legitimate, I get it. Other times, I will say to someone, hey, why have you had 4 sexual harassment cases in 5 years? And the response is, listen, all men are dumb little boys, and they do what they're told, and I know exactly what it takes to nudge these good little puppies into doing what I want them to do so I can sue them and make a lot of money. And so you call a witness in the room before you get sued for sexual harassment. Not that I would engage in sexual harassment, but sometimes, if somebody's voicing a desire to create sexual harassment as a cottage industry, which is incredibly rare. Like, I can't stress enough, the number of people over the course of my career who have expressed things along those lines, so few, less than 3% of all the potential clients I've ever spoken with. And also, these are not the kind of cases that we take. We're not interested in those cases. We don't want those cases. Why would we want to represent the serial entrapment artist? Fair point, though. people are like, oh, blah, blah, blah. It's not a case because it's entrapment. Disagree. I don't want that case, but it is a case. It doesn't matter that she entrapped some idiot or not. He's still engaged in sexual harassment. He made choices. He made the wrong choices. He did bad things. That is still a case. She's still been wronged. Is she perhaps complicit? Maybe. Is it not the ideal case because of the behavior she engaged in? Sure. Is it less of a feel-good case than average? Sure. Still a case. Not a case for me. Still a case. And I'm not throwing shade at the firms who are like, well, that guy should still be punished, because I kind of agree. I kind of agree. It's just not a case for me, right? It just is what it is. That's my take on it, but I still think it's a case. I still think she was wronged. It sucks that that's the behavior pattern that she would say that she's engaged in, or whoever it is, right? But these things happen, and it's rare. And yeah, I can understand. I can understand very, very much why defense counsel wants prior litigations. Also, listen, if you can get prior litigations, people do wild things in litigation. People lie, they fake documents, they like, and stuff comes out, right? Like, so you mentioned landlord-tenant litigation. You could have landlord-tenant litigation where people say wild things on the stand, like I oughta kill you. Well, if part of the allegation is, like, let's say you have a discrimination case and you're like, hey, have you engaged in prior litigation? And part of the defense in the discrimination case is, hey, this is actually discrimination. This person is like physically aggressive and threatening towards other staff members, so we had to let this person go, right? And so you've got the discrimination case going, and in discovery, the other side's like, yeah, we got to find out about your prior litigation, and they get it. And they get some landlord-tenant case where the person that they're saying is aggressive and threatening towards other staff is on the stand and says, I ought to kill you. Well, I got to tell you, that goes to show it's a piece of evidence supporting the idea that this person might be behaving in an aggressive fashion, right? I mean, is it the best evidence? No. It's certainly useful. It's certainly persuasive. And if you can get it in, I think juries are going to want to hear it. And it might really sway how they view the plaintiff. So there's every reason. Like, I know somebody down below, let's see, what is it? Diesel, YouTube user Diesel said, the fact that employment defense attorneys will try to state that someone being part of a case in the past makes them a litigious person is insane. I generally agree with that statement. Why is asserting your rights and protecting yourself from discrimination a bad thing? I agree with that statement as well. It's not necessarily that you've had prior cases. They may make that argument. I don't think that's a great argument. It's an argument, but and it's one they might make, Diesel. You're absolutely correct. But I think more likely is that they would like to mine the prior cases for data that might be supportive of their claims. Or just mine them from information about the plaintiff, right? Not everything is on social media. As much as defense counsel will try to mine social media to find out things about the plaintiff, it doesn't mean they couldn't find more information if they also mine prior cases, right? Somebody gets questioned under oath, who knows what they might say? But they might feel pressed to say, forced to say, right? So, to your point, Diesel, I agree with what you're saying, but that's not really the sole thing they're engaged in here. And scrolling back up, Larissa, yeah, I mean, listen, there are serial extortionists in the world. We're very fortunate in that we're very good at not representing them, right? It's pretty easy to not represent them. It's not something, it's very rare that one would get in the door here, right? But it happens, and I can see why defense counsel would want to know about that. It's valuable to them. It certainly furthers their position and helps them a great deal, potentially in their litigation. Anyways, I hope everyone's having a lovely Monday. Monday Fun Day? Is that a thing? No? You gotta love what you do. Come on, get out there. Make it happen. Comment down below. I mean, do you think people should be able to ask for prior litigations and discovery? Do you think that's a fair question or not a fair question? Do you see why people want to ask that question? And where do you fall on the issue of can they, can't they? Let me know. I would love to know. I am duty bound. I am contractually obligated. I am forced and ordered to say the following to you. Like, subscribe, and comment down below. Share the channel so it may grow. I don't know. Take care, everybody. Hope everybody's well.